Hello and welcome to College of Idaho Insights. I'm Dustin Wunderlich, and today I'm here with Professors Carrie Hunter and Jasper Lichelzy from the Department of Political Economy and Steve Mon from our Department of History. Today we'll be talking about a recent ABC article about some comments that former Justice Ginsburg made about South Africa being a model for Egypt's constitution. Jasper, tell us a little bit about Ginsburg's comments, and especially her comments about why the U.S. Constitution may not be as relevant to other nations developing constitutions today.
Well, this has caused a great deal of an uproar. It isn't so much this article was in about 100 different articles. If you look, it's caused a great uproar, especially amongst conservatives, because basically what she said is if Egypt's going to create a new constitution, they shouldn't use the United States Constitution as a model. At least that was the headline. But I think much of what her concern was, if you look at the American Constitution, it overall isn't very democratic. It looks at the nation and who should be involved with a real concern to the democratic masses. It also, if you look at the Constitution, isn't a great bulwark for human rights. And she suggested that the South African Constitution might be more of a model. And again, this has caused a great deal of uproar. How can she think of any other model than U.S. Constitution? But if you go around the world, there's very few constitutions like ours. When other countries have had the opportunity to choose a model for a constitution, they haven't used the United States model. And even when the United States has had a great deal of influence over a country's constitution, you look at Japan or more recently in Iraq, we've even told them, don't use our constitution as a model. And I think, though a lot of people are upset about that, I think there's a lot of concern that when you look at our constitution, based upon our current beliefs of democracy and inclusion, it falls very short, whether it's the Supreme Court, the Senate, the Electoral College. It doesn't really reflect contemporary views of participation by the general public.
But ironically, she suggested the South African Constitution, and she even mentions in the article that the South African Constitution is more clear in its creation of an independent judiciary and grants that judiciary clear judicial review power over the legislature, which is a very undemocratic position as well.
Well, I think she supports democracy, except for when you can have a court overlook it because of her privileged
Well, I
position.
think the critical transformation between the time the American Constitution was constituted and the Constitution of post-war, post-Second World War constitutions is precisely the formation of the United Nations and the Declaration of Universal Human Rights. This has transformed everything in terms of how constitutions mediate between the rights of minority groups in a general universalistic sense of theory of constitutions and the actual operation of them on the ground. This obviously was not operative at all in this. I mean, people were talking about it, but the experience of the French during their revolution suggests just how contested it was in the late 18th century. You know, the French were created the most advanced constitution in 1794 that provided complete equality for all classes of citizens, outlawed slavery, and of course then Napoleon Bonaparte, when we got a nationalist.
Advanced? I don't think Alexander Hamilton or Burke thought it was very advanced.
Well, they thought it was too advanced. They thought it was too advanced and it didn't protect property. And of course, at that point, property included people.
But the other change, I would argue, that has affected the creation of modern constitutions is the actual practice of American constitutionalism. Even though the framers failed to articulate the power of the Supreme Court to overturn an act of the legislature, that power was implied, or at least at least the presence of the Constitution implied such in the minds of a number of the founders. And the Supreme Court slowly began adopting that power and using that power. And one of the current arguments for a strong protection of minority rights is an independent judiciary which has that legal authority to rule against.
Has it, but doesn't necessarily.
But based upon the amendments that have been passed to the Constitution since its original formation.
Not even necessarily the amendments. There's no, I mean, the U.S. Supreme Court still does not have any written legal authority to overturn
No, I'm
an act
talking
of the
about
legislature.
the advancement of the concept
Right.
of human rights.
Right,
Through the evolution of the Constitution, but not the
But
court's
the idea
powers.
of
Right, I agree.
the Constitution being there to protect rights
Right.
is ultimately requiring a court that's independent from the legislature, capable of ruling the constitutionality of
Right.
the legislature.
But there's nothing, you know, in theory, yes, the court could do that, but there's nothing that says that they can or will.
Right.
Right.
But
So
the
to
news,
say that
and-
the court will, we have the court there to protect minority rights, well, they don't have to. though.
but the South African Constitution that Ginsburg is referring to says that indeed the court can
Mhm.
and will.
And in our particular case, we have a court that has now protected the rights of the smallest class, the smallest minority, artificial individuals, corporations, and their right to speak to the political process.
Hopefully soon robots, because they're artificial individuals too.
It reminds me of George Jetson. Remember Rosie, right? So she always had troubles, you know, dealing with the Jetson
she didn't
family. The
have full
Constitution,
rights.
she would have.
which for me really raises an interesting question. And if we're interested in preserving democracy, and yet we're also interested in preserving rights and having a court, an independent court, do this without any democratic recourse, court members are on for life, is the best way to do that to actually grant the court legal authority over the legislature, and thereby really turning democracy over to a court, or is it to do it the way our founders did, which is to kind of leave the question unopened? And I think I prefer the way the founders did it, insofar as the court, anytime the court acts to overturn an act of the legislature, they can't do it by saying we have legal authority to do so. They do it by it's a reference to
torturous
moral,
process.
a moral.
Yeah, exactly.
They can only do it by making a strong case that legitimizes their position, not on law, though they obviously always look at precedent. But again,
Always?
well, they tend to,
Some of them.
for the most part, or twist precedent. I mean, they look to it and then they manipulate it. But it still comes down to the capacity of making a moral argument, because there's nothing in the Constitution that says anyone has to follow what they want. Which in my mind is stronger than the South African Constitution for that very reason.
Is some of that moral authority, do you think, declining because there have been so many 5-4 decisions recently?
That's a good question. I mean, theoretically, you would think it would. Thus far, I don't see a lot of evidence that the court's authority has eroded, because we still tend to listen to it.
Well, much more so than, say, 150 years ago or so. Andrew Jackson had a tendency not to listen to the court, and Abraham Lincoln especially didn't believe it. And they saw the presidency also as another means for protecting minority, if not necessarily minority rights, as a protection against the majority. That if Congress would overstep its bounds, pass some legislation that was unconstitutional, it was the role of the president to step in, much more to veto legislation, and much more so that I don't really like what you did from a policy perspective, but I'm there as part of a protector of the Constitution.
Right.
And I think the presidents have given that over to the courts to a great extent.
But I think this is also very powerfully situational. I think it's much easier to make an argument for a court that has power to speak in a larger civil discourse in a large, stable, affluent republic than it is to say this should be the pattern and basis upon which we try and forge governance in a place like Egypt, which is volatile and doesn't have a series of traditions about the legitimacy of the public process of creating of creating law, and I think that's one of the reasons why there's a disconnect between what Ginsburg says and what conservatives in America react to when they look at that point of view.
Well, Ginsburg mentions that clearly in her speech too, that a constitution isn't enough. It's a culture that's important, and I would say one thing other countries have received from the United States, if not the processes from our Constitution, it's our belief, you were saying, in constitutionality, in the belief that the Constitution is ruling, and just because you disagree with it, you don't go out into the streets.
Yeah, well, but again, remember, even in the U.S., this was slow to develop.
Yes.
I mean, the Supreme Court was very tentative initially about taking on the legislature. And
you're very strategic.
And very strategic.
How Marshall did it.
But your question, has their moral authority eroded with 5-4 decisions? Again, I don't think that it's clear that it has, but it could. And over time, if the Supreme Court is viewed as purely a legal body which is making these rules 5-4, depending on who's on the court, the more we view the court in that way, the more its authority the more its moral authority can be eroded. However, because it's such a powerful institution in our society, right now what we do is we try to change the makeup of the court. When the court ruled in Roe v. Wade, for example, the way that it did, the response by the conservatives was, well, we got to get new people on the court. So that politicizes the court, so it becomes just okay, if we're going to have the court making law for us, we have to try to make sure we have the right people on the court, which in my mind is not a good way to go, but it may be the way we continue to go if the court cannot make rulings that are more unanimous. Now that's something that
you can bring up your theory on healthcare reform
sure,
on this too.
Chief Justice Roberts, before he was Chief Justice, argued that the court should speak with more as one voice, because understanding Hamilton, understanding Marshall, understanding even Burger, Chief Justice Burger in the U.S. versus Nixon case, where Burger believed the court needed to speak unanimously if it was going to tell President Nixon, you got to hand over the tapes. Roberts believes that the court does speak with more moral authority when it has a unanimous decision.
And Brown versus Board of Education was unanimous.
Same thing. When you're going to make a decision that's that important to the nation, the court ought to speak with one voice. I believe that given that the court, the Roberts court, today's so-called conservative court, has allowed for 5 hours of oral argument for the health care law, for example, that's indicative of Roberts recognizing this is important, and I believe Roberts is going to do his best to have a united court. I don't think he's going to get a unanimous court, but I think it's quite possible he could get an 8-1 court ruling in favor of health care. That seems like a bizarre statement to make if we're talking about a so-called conservative court. But I think that it's quite possible that will be the direction, given past precedent, and ultimately given Justice Kennedy, who's sitting in the middle, and Kennedy's past precedent with regard to the Commerce Clause. I think it's quite possible he could go in favor of Obamacare, which means I think. Well,
and then Roberts says, if it's going to be 5, if that's the way the decision's going, I better move over there. If he moves over there,
he might
bring Alito with him, and that makes a lot of sense. If we're going to make a big decision, where's the chips going to fall? And then let's get most of us on there, so we have that moral authority more than just a 5-4 decision that it looks like so they stop looking like the Congress.
The very last thing Roberts, as Chief Justice, wants on this is to be a dissenter. At least I think if he understands, and I think he does understand his role as the chief on something this big, he has got to be with the majority. So I'm guessing he's not. I'm guessing it's quite possible it could go that other way, but it's controversial, and it's very possible it won't.
But this gets us back to precisely the question of the fit of a constitution to a political culture. and what a political culture will accept. Because this kind of politicking is not necessarily useful in a recently founded and growing political democracy. This is one of the reasons why when Ginsburg references the South African Constitution, and built into the heart of it is essentially language that reinforces the Truth and Reconciliation Commissions in their attempt to heal a nation that had been split on racial apartheid laws for decades, making an attempt to create a united political culture was part and parcel of how that Constitution was formulated to begin with. In the same way, the American founders created a Constitution that left a whole series of questions unresolved, precisely because they couldn't be resolved. The ticking time bomb of slavery, for example, and property and people, which obviously exploded, right, sort of 60, 70 years later, was one of the greatest examples of the fact that constitutions are as much a product of the time in which they're formulated as they are of universalist principles guiding how they should operate.
And in fact, in light of that statement, there are those who argue the Supreme Court's Dred Scott opinion, which in a sense basically told the legislature they could not make a compromise over slavery. What has been considered to be one of the sparks that led the Civil War. It's basically saying that Congress cannot make compromises to deal with the slavery question due to the rigidity of the Constitution, which promises slavery forever, in a sense, and the court ruling that indeed we have to go with the Constitution
and ruling
rather than the legislature.
Rather than fundamentally with a democratic process
Right.
regarding the most contentious and potentially explosive issues that divide a society. And that, I think you're right, does become really problematic when what is a fundamentally undemocratic institution steps in and on the most important issues says, we're going to shut off the democratic process.
But you look historically, though, I think the court hasn't done that.
Not on a regular basis.
Not on a regular
Right.
basis, is they do understand the movement. And that's what bothers me with some people who look to say, we need to go back and look at the Constitution in its original intent, because we're not that same society. And Robert Dahl, in one book I used in my class, How Democratic is the American Constitution, he said, if the Constitution would have been written in the 1820s or 1830s, it would have been completely different. And I think you can speak to this too. You know, why do we have our Congress? We have a problem. Why this independent president? They didn't have any other models, really, and they looked to the British somewhat. They got a king,
Right.
and how are we going to deal with that? But by the 20s,
Lords and Commons.
yeah, exactly. That's what they were trying. That's what they modeled it after. You said we get to the 20s or 30s, how much more 1820s or 30s, how much more democratic the country was. You would have created a much different. And why didn't we have a parliament? Because the parliamentary system we think of now, the Westminster Monarchy, wasn't around at that time for them to
certainly
emulate.
wasn't a democratic
At least
model
not
in the
that way.
same kind of way that it is and became after 1910 in Britain itself. So,
But even a little bit after that, they're starting to get away from, so much less power to the king.
Well, 1910 was essentially the year in which laws were passed that prevented the House of Lords from acting as an absolute veto on democratic popular legislation.
My problem with the original intent folk is that they aren't original enough. In my mind, if you actually read the intent of certain founders, and that's part of the problem, is which founder's
ones,
intent do you want to follow? Certainly if you want to follow the intent of Hamilton, for example, one of the authors of the Federalist Papers, I think his intent very much was for the Supreme Court and the country to grow, to adopt to the different situations. Hamilton did not see the U.S. Constitution as something that was set in stone that would dictate even the ruling of the U.S. Supreme Court. Hamilton envisioned the court as having the need to be able to broadly interpret that Constitution in a way that would allow for flexibility. So if
Why look at
he's
him
one of
as
the
a-
original intenter, if he's one of the originals,
And everybody does use it, but why? He was when he was at the Constitutional Convention, He was there with two other members from New York who left. He was there by himself. He left by July. His one speech completely was met with such disgust was when he was saying that we really need a king. That's the only way this. Everyone just kind of said, okay, next, and then he basically left. So when you talk about who was influential within the convention, he was very.
Right.
Now, if you talk about who was influential after the Constitution was
That's
written,
a separate issue,
he
right?
was much
because,
more.
Because that's where you get the split between the Democrats and the Federalists, and
With him and Madison,
well,
which is-
exactly,
which
well,
is
exactly
odd.
so.
Although he and Madison are working together to pass the stupid
Right,
thing in the first
which
place.
again speaks to the fact that in a fundamental way it really is a compromised document, and the notion that you can read the original intent of the Constitution has enormous appeal, particularly in a country where people make appeal to the authority of other kinds of texts like Scripture, that we can determine the intent in the mind of God by reading clearly and closely the New and Old Testaments.
And that works really well,
Well,
doesn't
this is of course the problem in religious history. We live in an era of voluntary religion precisely because of constitutionalism, not because that some kind of clear and unifying truth has emerged out of religious discourse. But the originalists want us to return to that model of interpretation of the Constitution, which goes against precisely the idea of creating a Constitution in the first place in the minds of the theorists of the 18th century. So, I mean, it's
And they
a real
really don't, though.
catch-22.
They really don't in many respects. Do we really want to go back to the original intent of the Electoral College? People in Idaho are upset now. Well, we don't even like these caucuses aren't democratic enough that we're going to have. And yet, let's go back to the state legislatures, which is really what they were looking at. The state legislatures choosing these electors who would basically choose the president, and most times they probably wouldn't come up with a president, and Congress would choose.
And we certainly
Nobody would put up
we
with
certainly
it.
haven't amended the Constitution to do away with the
We
Electoral
just changed- we
College.
just-
So it's still there. So
Yeah.
yeah, you're right. I mean, if we really want original intent, we need to go back to that.
And many other, and actually there was a few people pushing for this. Let's go back to senators chosen by the state legislature. And anybody who's been down
Well, these
to
become
Boise
sticks-
during the state
these become
legislatures in
sticks
town,
to
that's the
beat the
last thing.
pragmatic practice of politics under an often ambiguous and evolving constitution. But originalists don't like to believe that things evolve. They like to make the argument that there's a firm rock upon which our understanding our union rests, and of course we have those who are chipping away at that foundation, and they should be excoriated publicly because they don't understand the danger to the Constitution that they are encouraging. This, again, I think is an untenable view with any kind of historical awareness of constitutionalism itself and of the evolution and the founding of new constitutions in the last 200, 240 years.
I think to get back to Ginsburg a little bit, I think if you asked Americans today, if we were starting off from scratch, like the Egyptians are, would you choose this constitution? No. We said you're not going to be your chief executive. You're not going to be allowed to choose directly.
Depends on which Americans.
Yeah, exactly.
If you tell them
minority of 20% would say
no,
yes,
you don't ask
absolutely.
them.
Without understanding,
Right.
without understanding what's
Right.
in it, they would
Right.
say yes, we should.
Well, that's what I say. You don't
It's
ask.
kind of
Would
like-
you accept this American Constitution? You don't ask them that. You ask them the specifics that are in there,
Right.
and they'll say no way.
Depends
can-
on how you poll, doesn't it?
Yes, exactly. That if we ask people today, what's specifically in the Constitution, even now, as compared to even then, I mean, would you want this? No, we don't want to change to that, which is basically what we have, because the way we've interpreted and evolved has changed it so greatly, you can't even understand it, that it's hardly worthwhile.
Well, thank you for participating in today's discussion, and thank you to all of our viewers. And if you have any questions or topics you'd like us to discuss in the future, please email communications@collegeofidaho.edu. Thank you.